Good afternoon, and welcome to part 2 of our Seeking and Negotiating for Outside Employment Massive Open Online course. We hope you're able to watch the broadcast on Tuesday, where we covered an introduction to Subpart F of the Standards of Conduct. And also we hope that you had an opportunity to look through the exercises and maybe give them a try. So today what we'd like to do is to go through those exercises and give you guys some opportunities to ask any questions that you might have. So Cheryl, we did receive a question from a viewer of our previous presentation, the one on Tuesday. From Tuesday, seeking clarification on a particular issue. And I think this is kind of an interesting question. So the question is, we understand that if an outside company or outside employer says to an employee of the government that they are interested in pursuing an employment relationship, and the employee issues a statement to them other than a rejection. So they say, maybe let's talk about it later. Let me think about it. Let me talk to my spouse, any of those things. We understand that employee to be seeking employment for purposes of Subpart F.
Yes.
Until such time as those discussions have been completely cut off and finished.
Right.
So the question is this. In the inverse, so an employee submits a resume to a company seeking a particular position. And the company responds to the employee and says, well, actually that position's closed and we filled it, but we may have something else for you. Let us have a look. You're the kind of candidate we'd be interested in. And our employee says nothing in response to this. Is that employee at this juncture still seeking?
I would argue that yes, because basically you're still being considered, the employee is still being considered for employment by the prospective employer.
Right.
So their resume is still active with the prospective employer. Now, I don't think that that's an indefinite sort of seeking situation. I think when you look at it from that standpoint, what are our facts on the ground? Our facts on the ground are the employee sent a resume to this organization. This organization responded with not a categorical rejection, but kind of a deferment for future consideration. So in my opinion, I think that we're still contending with the 2-month, if you haven't heard a response, like a positive response, or aren't engaged in some sort of a back and forth within 2 months of the original date, I guess, that you had issued your resume, then you really, the seeking employment has
expired until such time that you heard something back.
Exactly.
And that makes sense, because it could be that the company is just being polite.
Right.
But still, while there's the possibility, while your resume is in the possession of the company and is being considered for all you know, it seems to me to be sort of analogous to that same situation where you've sent it, you don't really know what's going on, but you understand that you might be under consideration.
Exactly. So again, I think in that situation, it's the 2-month tolling piece, I think, is still in play. But I don't think that the fact that they simply said the thing for which you may originally have sent your resume is no longer in play, we are considering your resume for something else. I think that that's not, you haven't ceased seeking employment, unless of course you say, well, I'm not interested in any other position. Thank you very much, whatever. But if it's this kind of, it's being held in abeyance for a future determination, I think you've got the 2-month period that is in play there.
Okay. No, I think that makes a lot of sense. And that's a great question, because I think that is a thing that happens sometimes. So, too late for that one. Maybe another one is available. Excellent.
Okay, so shall we jump into the exercises
book?
And I do hope that everyone had a chance to at least look at these exercises and at least think about them, even if you didn't formally go through and formulate answers to each of the questions.
And again, these are available on Max for anyone who hasn't found them yet. They're on the Max page that you registered for this course on.
Exactly. So if we could go to the first question, Patrick. Scroll down to the first question. Okay, so our first question is, in the first scenario that we gave you was this, which is we have a government auditor who's working with an IG shop, and they're doing their auditing work, looking at the accounts of a particular contractor. And while they're in the business of engaging in doing their auditing work at this contractor's facility, the head of the contractor's accounting office sort of tells the employee, well, we're thinking about hiring another accountant. and the employee expresses some sort of interest of like, oh, wow, that's great. And to the point where they even ask if they might be qualified for the job. Okay. So I'm curious, Patrick, what do you think about that in terms of with the way that we've defined seeking employment and the kinds of activities that trigger Subpart F concerns?
Right.
Do you think this employee has done anything that should make us be concerned that Subpart F might be in play here?
Well, I'm sort of thinking about the breadth of Subpart F and that Subpart F is inclusive. See, the definition of seeking for Subpart F is inclusive of even unilateral communications that are aimed at securing future employment. And in this case, it seems that we have, however preliminary they may be, bilateral discussions of a possible employment relationship, as well as sort of a response from our employee that is other than a rejection of the overture. So it seems to me this looks like seeking.
I think so too. I think we're definitely in seeking. I'm with you in that without more facts about exactly the depth and breadth and scope of the bilateral communication that we might even be bordering on negotiating here, which would take us from a regulatory concern to a criminal concern under 208. But I think for me, the interesting thing here is that I'm not sure if the only facts that I had were that the employee said, if the employee were to have come to me and said, the guy at the contractor basically indicated that there might be some openings there. And that was the sum total, that it was just kind of dropping generally this, we're considering hiring people. And that was like the sum total of the conversation. I would say that maybe the employee is just on the cusp of seeking. But the employee kind of just kind of bolted straight forward into seeking and perhaps even into negotiating by pursuing that lead.
Right.
And saying, oh, well, yeah, I think I might be interested in that. And do you think I'm qualified?
Yeah. And I think scenarios like this are really effective as training tools with our employees.
Yes.
Because if I'm sort of an employee, not an ethics official, and I'm using kind of my common sense understanding of seeking or negotiating for employment, this doesn't feel like either of those things in kind of the common way that we use those words. But for the purpose of the regulation, I think we're comfortably within the seeking here, and again, sort of bordering on negotiating. And that's a very dangerous place to be. So I think, using a scenario like this could be effective as a training tool.
So we both feel very comfortable that we think that our employee is engaged in an activity that has triggered concerns under Subpart F.
Right.
Now, clearly, we're only concerned about those kinds of communications when the employee has duties that could be affected, or when the employee has duties that can affect the financial interest of someone with whom they're engaged in these employment search activities. Yeah. Do we think that's the case?
Yeah. So I think for me, this is where the alarm really goes off.
Right.
Is that this person is on site doing work with the contractor, the prospective employer. Presumably, they're going to go back to work.
Yes.
And if they were to do so, they could potentially contravene Subpart F or even Section 208. And that's a scary place to be.
And that is the really scary place to be. And that's why this one really does need to be a learning tool for you to use with any folks who are, directly engaging with contractors or with folks who can be affected by the work that they're doing, is because these kind of things do happen where somebody's on site, they're engaged in their official duty activities, and these seeking employment things come up right then and there.
Right.
And, by virtue of the letter of the law, I mean, once you're seeking employment, you're seeking employment. And if you're engaged in an activity at that moment where, that matter can affect the interests of that person that you're having that conversation with, you are technically, as you said, I think, potentially violating at least the regulatory provisions, and you're well on your way to a potential criminal violation. Right. So employees have to understand that it's not that they can't ever have any kind of a job search conversation with businesses that they're actually doing business with, but that the result of that is that they can no longer continue to work on that matter. Right. And that means immediately, they have to immediately stop working on that matter.
Right. So that's a tricky place for our auditor to be in. And I think the other thing that we want to train on in these kinds of situations is how do you, in the case that this auditor wants to pursue this employment discussion, how do they extricate themselves sort of artfully from that work? Who do they tell? What are the steps to avoid violating Subpart F or or 18 U.S.C. Section 208, because it's one thing to know that if you continue to work, you will. It's another thing to be able to sort of end that participation in the matter to avoid the violation. Exactly.
And this kind of gets back to sort of if any of you were watching the annual training modules that Patrick has introduced, and we've had several sessions about, this is exactly the kind of question that would be perfect for an annual training type of environment where you're effectively doing just that. You're not only concerned with trying to help people identify when they're in that situation, but more importantly, you're helping them identify how to get out of that situation safely.
Right, that's exactly right. And yeah, another thing that I like to sort of make clear in these cases is that people say, well, who's going to know? Right, what's the possibility of detection? And that's sort of very short-sighted, because the end game here is that you end up working for the contractor.
Right.
And that's the sort of thing that tends to be noticed by colleagues, former colleagues, people at competing contractors or your own firm or whatever. It's kind of a visible process. So I think we see a lot of detection in areas surrounding people moving from the government to the private sector, especially when they're working with companies that do business with their agencies. So your employees really want to be well protected and to navigate these shoals carefully and thoughtfully, so that if there are any questions after the fact, they're protected.
So moving on to the next part of the inquiry here. We talked about how the Stop Trading on Congressional Knowledge Act has created for public filers this notification of negotiation requirement. So what do you think about that, Patrick? Whether or not our employee would have that requirement?
Well, I think it depends. We're going to have to find out more about this employee. I think principally we're going to have to figure out whether or not this is someone who completes a public financial disclosure report. If they're a public filer, then they have to notify. And in this case, we don't know. So if we were counseling, it would be a good thing to either look up or ask. If we knew as a training audience that these people were public filers, it's a good thing to make them aware of additionally.
Right. And I think the bigger question here is, once you know that they, or, the question for them is going to be, at what point am I required to file this notification of negotiation? And I would argue that even on the face of the facts that we have here, since Patrick and I both think that there are enough indicia that they could be well on their way to negotiating at this point, that I would recommend that if they're going to pursue this, that they file a notification statement immediately, was within 3 days of having had this conversation with this contractor, that they should be filing the notification of negotiation, along with
the recusal,
because they clearly are going to have a recusal.
They're not going to be able to finish this audit.
No, they're not. They're going to have to recuse themselves from it, and there's going to have to be somebody else assigned. Okay. So Mia, can we open up the phone just to see if anybody on the phone has any questions about that particular scenario?
Yes, thank you. If you'd like to ask a question, please press star and 1. Be sure to unmute your phone and record your name clearly. Again, star and 1 with any questions. One moment while we wait for the first one.
We'd like to remind folks on the Hangout that if you have any questions, you can type those in the lower right-hand corner of your screen, and we'll be able to see them, and we'll be happy to address them.
We have no questions.
Okay.
And I'm not showing any on the Hangout. It looks like the first question was maybe an easy one.
I think it was a fairly straightforward one.
I think they get a little more challenging from here.
Yeah. Okay, so here we are with number 2. Now we're dealing with a senior political appointee. So I think the filing status of this person is a little more readily
discernible. Yes.
They're at a large department, and they receive a telephone call from the managing partner of an international law firm. And the managing partner says, hey, would you like to come in next week for sort of an exploratory, chat interview with us? And the senior appointee says, maybe. Let me think about it.
Okay.
So what do you think about this? Do we think we have any kind of a seeking employment concern here?
I think this is a little bit trickier. This is not quite as clear, I think. But sort of thinking about our definition of seeking, which is inclusive of even unilateral communications,
right?
Which is sort of what this is. We have a prospective employer, someone who may be a prospective employer, who's made a communication that was maybe welcome, maybe not. We don't really know how the senior appointee feels about this.
Right.
But they've communicated a preference other than I'm not interested.
Right.
And I think when we look at the definition, the standard is that communication is active and you are seeking until you have said, I'm not interested.
Right.
And we're not going to go forward here. So I think this is another case where the senior appointee probably doesn't feel like he or she is seeking. But I think per our regulation, Subpart F, seeking.
Yes, exactly. I would agree with you, because I think there was a unilateral communication clearly with a view towards prospective employment, which was coming from the prospective employer. And the words, maybe let me think about it,
Right.
in nobody's estimation, is a declination of interest.
Right.
So I think that we definitely have at least a seeking situation.
Yep.
Now, what I'm concerned about is, moreover, is what's going to happen next week.
Right.
And so my question to you, Patrick, is, do the words exploratory in any way inform your perception or your perspective on whether or not what would happen next week if our employee attends would take us into interview, potentially into negotiation mode?
No, I think that's an interesting question. I think the phrase exploratory is probably not helpful for our appointee to notice that he or she is seeking. But for our purposes, I don't think it matters that the appointee or the firm haven't decided exactly which position would be the best, or even if it would be a good fit at all. It's certainly possible that they could enter into negotiations without having identified a specific position, a specific geographic location that the work will be taken. But that discussion even is part of the negotiation, right? If you say, well, I'd like to come in, but I don't want to start as a junior partner. I'll come in only as a senior partner, and I want to half my equity buy-in. That's a negotiation, right? That is negotiating. So I think the idea of sort of exploratory, the openness of it, isn't a prophylaxis against stumbling into negotiation.
I would agree, because I think when you look at the definition of negotiating and negotiation under, as we define it even in Subpart F, and we looked at that on Tuesday, and that's one of the reasons why we've crafted Subpart F the way we have, is because it's very unclear when negotiation actually begins. But we say it's, a communication mutually conducted with a view towards, a job, you know? And I think that an exploratory conversation about a job is a communication that is mutually conducted toward, unless he sits there stone silent, but even if he did, so I think that just given the breadth of the definition of negotiation, I would submit that if this employee does go and attend this event next week, that I think that he or she is likely negotiating at that point. So my question then too is, do we have a recusal requirement? Do we think there's a disqualification requirement at this point?
What we don't really know, right? We'd have to figure out, what this appointee was in charge of, whether or not the duties of the appointee or the duties of the staff that the appointee oversees have any nexus with the firm. That could require all sorts of things. We might have to learn more about the firm and any clients they might represent or work they're involved in, or what kind of areas of law they participate in, and more about the appointee. What are their responsibilities? What are their duties? But with the very senior folks, this can be challenging because they can be responsible for an awful lot of stuff.
Exactly.
So there's a potential, I think, here for, depending on the facts, a fairly broad recusal requirement.
Yes.
That could be maybe not. It could really hinder their ability to perform in the role.
Yeah, if it materially impairs their ability to do their job, you could. If they're having to disqualify themselves from a lot of different things. This could be, a pretty big deal.
Right.
I think one of the things that I want to remind everybody too, or just make sure that we're all clear on, and so that you can help your appointees and your employees be clear on, is that recusal requirement kicks in at the point that they're seeking. So even after just this conversation,
the recusal requirement
is initiated from this point forward.
Right.
So your employee would need to know you have a recusal requirement from the moment that person called you expressing this interest in meeting with you, and you did not categorically decline. And so don't think that you have until you've gone to this meeting next week before you have to consider disqualifying yourself.
Exactly. There's no room sort of to put things to bed or reassign them or sort them out, through participation. The recusal is immediate.
That's right.
Yeah.
And I wanted to just sort of alert folks to this fact. And it's something that we address explicitly in the 2004 advisory that we gave you a copy of. And it's on page 3, where we talk about employees need to know that their recusal obligations are unaffected by subjective factors, such as whether they just think they're testing the waters or they're not really serious about the job. That, in fact, OG has reported one case in which the Department of Justice proceeded against an employee under Section 208, even though the employee ultimately declined the offer of employment. And you can find that in one of our prosecution surveys from back in February 12th of 2002. So this is really serious. And obviously the Department of Justice takes it very seriously too, that whether or not the employee, him or herself, thinks that they're serious about the pursuit of the job that's being offered, if they're engaged in communications about prospective employment, they have duties that can affect the prospective employer, that recusal requirement is real, and it's taken very seriously, irrespective of how interested or not interested ultimately the employee is in employment with that particular employer.
Actually, that leads in nicely to a question we have from Alex, and he says, you kind of laugh about whether they are seeking or not after a call like this. Does that mean you find that sometimes folks don't recognize a call like this would constitute seeking? And I think that's definitely something we find in training frequently, is that from a common sense understanding, they say, I haven't even said I'm interested yet. That doesn't seem like a big deal. That might not sort of weigh heavily on people's ideas of, sort of what's permitted under the rules. So this is a place that I think is very useful to train on, to sensitize people about how little contact is required to constitute seeking. So we emphasize this again and again and try and sort of present people with a spectrum of communications that constitute seeking, because I think we all understand that once we start talking about salary, okay, now we get it. We're definitely in negotiations. We know what the job's going to be. We're trying to decide where it's going to take place and how much money I'm going to get paid. Everyone kind of understands that intuitively. But when someone says to you at a party or gives you a call and says, you might be a good fit over here, would you think about coming and talking to some of my colleagues? That feels categorically different for some employees.
Yes, and I do, and I think it's for everybody, frankly. And I think it's because we can, as much as we want to in our regulation, talk about unilateral communications with a view towards employment, and anything but a rejection of a unilateral communication and indicating employment. And that's all lovely and great to create these what is basically a very broad definition of when an activity would fall within the ambit of what we call seeking. But I think we have to put it into real terms that people understand, because I think most people don't think about unilateral communications in the context of, they think about, somebody called me on the phone and said, hey, we think we've got an opening for you. Think you might be interested. So we got to kind of meet people where they live. And I think fully expect that most folks aren't going to recognize these activities necessarily as being things that are the red flag for a disqualification requirement.
Right. I think of it as sort of the financialization fallacy. People think, until the money topic comes up, nothing's happening. And I can understand that, because we focus a lot on financial disclosure, and a lot of it has to do with wealth and money and investments. And so conversations that aren't about money specifically don't feel like the right kind of thing. It's an area we want to train on.
And so, I think if we're dealing with a senior political appointee, it's probably pretty likely that they're subject to the negotiation notification requirement. So I would say yes, that they would have that as a requirement. The question again becomes, when should they file that? In OG's guidance that we've issued, we say that an employee may elect to file these before they are technically negotiating, and that will hold them in good stead even once they start negotiating. Like, they don't have to refile something once negotiation actually, they're engaged in negotiation. And I think that that's a good
That makes sense.
That's a good practice, particularly like in this circumstance. You know, what I would recommend to an agency ethics official to tell their employees is, the minute you think you're interested in starting to talk to someone, we'd really like to know about it. So why don't we just have you file your notification statement then, and then we can counsel you and you're good to go, you know. And
if I was the ethics official in this case and this employee's just received this call and they're coming to talk to me, they're probably coming to talk to me about whether they're going to go to the meeting.
Right.
And I'm going to say, if you're going to go to the meeting, that's going to be negotiating and you're going to have to file this thing. We can just do it now.
Right.
If they're saying, I think I don't like the recusal requirements that would come with this, I'm going to call them back when I get back to my desk and tell them I'm not doing it. That's fine. Then we don't need to do anything.
Right.
But I think that's how I'd handle it.
Yes, I think that's perfect. And of course, if there are matters that they have before them where they would require recusal, they would file the recusal statement, I would argue, concurrent with the negotiating statement. Okay.
All right.
Do we have any questions on the phone about that scenario?
Again, if you'd like to ask a question, please press star and 1 and record your name, star and 1 with any questions.
I'm not showing any questions on
No
the Hang
questions from the phone.
Great,
Okay,
thanks,
very
ma'am.
good. Thank you. Okay, so let's move on to number 3. Okay, here we have an SGE, Special Government Employee, and they're with the National Science Foundation. They've been approached by an NSF grantee about a consulting contract.
Okay.
Okay. And the SGE has indicated that they generally are interested in a potential consulting contract, but only after their grant review work with the National Science Foundation is completed.
This is a tricky one.
It's tricky. Yes.
Because consultant, when we look at the language in 208, is not on that big list of people whose interests are imputed to us, and that could cause us some confusion. But I think we have to remember the breadth of our definition of seeking, which basically says if you're looking for an arrangement of basically any remunerated personal contracting or whatever, those are still considered seeking for purposes of Subpart F. So on that view, the kind of work that this person is discussing seems like the kind of work that we cover under Subpart F.
Yes, exactly. Because if we look at the definition, if you look back at the definition of employment, and this would be one of those times where I would encourage you again, if you have any questions about whether or not this is the kind of thing that's covered, is to go back and look at that definition of employment under 2635-603. And it says, it includes, but is not limited to, personal services as an officer, director, employee, agent, attorney, consultant, contractor, general partner, or trustee. So I think clearly consulting work, contract, whether you're considered to be a contractor or whether you're considered to be a consultant, one way or the other, you're hiring yourself out, your personal services out ostensibly. So yeah, this is covered by the seeking provisions.
And the fact that we've sort of deferred this discussion also doesn't absolve us, because in order to end seeking, we have to decline without condition.
Right.
And in this case, simply deferring is not a declination.
Right.
So I think we're seeking.
I think we're seeking too. I agree completely. I think the trickier question here is, and it may not be tricky, like I think is if your practice is always to not make any assumptions about whether or not the person has duties that can affect the prospective employer. But if we just look at the language on the face of the scenario we have here, we're talking about it's a grantee, an NSF grantee that's approaching the SGE, and we know the SGE evidently is involved in grant review work.
Right.
So some red flags should go up at the very least.
Right.
But do we have anything that's here that's necessarily dispositive that the person has any recusal requirements at this point?
No, I think we could but for other facts, we could take a sort of an advisory or a cautionary approach. And advise this person that if it so happens that you're asked to review a grant or other matter involving this grantee, you can't. The recusal requirement exists, whether we've identified it specifically or the specific instance or not, and that you're responsible, that if something like this comes up, that you can't work on it. Or if we know that the likelihood is significant that a matter will come up, we can put in place the necessary screening arrangements and inform the necessary people to keep this person out of those matters.
Yes. Now, the thing that I would sort of as a cautionary for all of us is is to make sure that, I mean, I think we can readily recognize if you get a grant application from this grantee, then clearly that's a matter you can't work on because clearly they're affected by that.
Right.
But there are instances where you might be disqualified from an entire grant making review because like, so let's say you have an instance where you have a limited pool of grant money and every grant application is competing for the same pool of money.
And they're a competitor.
So then I would argue that if the person that's offering them this potential consulting contract and they're seeking employment with is one of the applicants in that pool of applicants, they're disqualified from that entire pool.
Right. So it'd be sort of analogous to sort of contract situations where we're trying to decide who's going to do the work, who's going to get the money. Well, we don't have to be deciding that this contractor is going to get the money. The decision to give it to one of the group of competitors is sufficient to trigger the disqualification requirement.
Exactly.
That makes sense.
Exactly. So with respect to the negotiating notification, what do you think about that one?
This one's tricky because, you know, many of our SGEs are 450 filers.
Right.
And 450 filers aren't subject to the negotiation notification.
That's correct.
But some of our SGEs do file public financial disclosure reports.
That's true.
And if I'm recalling our Stock Act guidance correctly, it seems that there is no dispensation for SGEs. If you file a public report, you file negotiation notifications, full stop.
Right.
So if this person's a public filer, they have to file the negotiation notification.
Now, they are subject to the requirement. They're subject to the requirement if they are a public filer. I think the key here, and this is what you would have to ferret out as the ethics official, is the negotiation notification requirement is only required if the employment or the compensation for personal services is going to occur once government service has ceased.
Right.
So we would have to figure out whether or not this contracting consulting relationship would be concurrent with their SGE appointment, or whether it would actually occur
at the close of the term,
post government service. So that would be the tricky piece, I think, that you would just have to sort of ferret out with your SGE, and sort of figure out when their appointment expires, or, you know, when they would ostensibly no longer be in government service, to ascertain whether or not this particular thing would require the negotiation notification.
Right. And we just use the best information that we have now to make that determination. You know, we understand it's possible they could be reappointed, or they could be rehired by by NSF in some other capacity.
Right.
But what we'd be looking at is, at this juncture, does this appear to be work that you're going to undertake after the close of your appointment? That's
correct.
Okay.
That's correct. Okay. Any questions on the phone about that one?
Again, if you'd like to ask a question, please press star and 1 and record your name. Again, star and 1 with any questions. No questions from the phones.
Okay.
And we don't have any on the Hangout either.
Okay.
So on to the next one.
You want to read this one out, Patrick?
Sure. So we have a retiring senior employee at the FDIC who is responsible for overseeing the promulgation of rules regulating all the member banks. And this person has mailed an unsolicited letter to a member bank offering her services as a contract consultant once she leaves government service.
Ooh.
So a retiring senior employee at FDIC sends a letter to basically a regulated entity.
Right. Right.
Interesting.
It is very interesting.
Yeah.
And this one's going to get a little complex.
Yes.
Because if we let's talk about whether or not this person is seeking, from the standpoint of the general sensibility about this person has sent an unsolicited letter offering their services to someone who clearly can be affected by her duties.
So generally speaking, a unilateral communication about future employment is seeking.
Yes.
You know, at least for that time period, for 2 months or whatever it is, until we hear back. So I think as a general matter, yeah, we've hopped over that first bar. But then it gets tricky, right? Because then we have to go to work, and there are slightly different standards depending on what we're doing.
Right. So as we said on Tuesday, there is this kind of odd little carve out that we have, which basically says, okay, so if our senior employee here, our retiring senior employee, is working on nothing but these what we call matters of general applicability, which is to say the sum total of all of their duties are simply these matters,
these policies and
regulations that can only affect the member banks
as a group,
as an entire group,
and not specially or specifically amongst them.
Right. So this employee would, if this employee is in a position where they have absolutely no matters before them that discreetly affect this member bank or discreetly affect this member bank, then they don't have a disqualification requirement yet because we've had that carve out that says, okay, you're not really in disqualification mode. You're not really having to suffer the disqualification requirement of seeking if you did a unilateral communication and it was someone who you can affect only. The only duties you have are ones that can affect them as just part of a class or part of a group.
Yes, I think about it as sort of a timeline that for those particular matters of general applicability, if that's what you're working on, we push back the moment of seeking until you've heard back. So during this sort of interim period between when you've made the communication and when you hear back with something other than a no, you may continue to participate in those particular matters of general applicability.
Right.
So the question we'd have to answer here is, what is this person working on?
Exactly.
Are they only particular matters of general applicability? If they're specific party matters,
they're seeking, and they're disqualified from everything.
Right. So that's the question.
Right.
So we'd have to get more information and determine whether or not we could rely upon that sort of dispensation,
right,
or that delay of the seeking,
right,
because they're only working on those particular matters of general applicability.
Right. And I think this gets really pretty serious for folks, particularly the higher up in the chain, the food chain you go, because it may very well be that a senior person in this area, that the people that work under them are only working on regulatory matters, but by dint of where they are in the food chain, they actually are called upon to engage in other government matters that are discreetly affecting or discreetly involving the member banks. So we want to ferret through this very, very clearly. And again, I want to remind folks that even if this senior employee is only working on matters of general applicability, rules and policies that affect all member banks equally, that dispensation from the recusal requirement is only until they hear back.
Right.
Once they hear back from the member bank, boom, all bets are off, and they're now fully squarely within seeking employment, and they have a recusal requirement.
Recusal requirement, yeah. So we have to kind of look at the seeking and recusal questions at the same time here. Right there. In this case, more than many others, they're sort of very intimately related.
And I think most importantly here, though, is, we're getting into the weeds about whether or not this person is yet seeking and whether or not they have a disqualification requirement. At the end of the day, as the ethics official, you're going to want to know about this as soon as possible, because if you're dealing with someone who is fully in charge of an entire unit that regulates this group of member banks, that disqualification is going to be pretty immense. I mean, the ramifications of that disqualification, if and or when it occurs, is going to be pretty significant. And those are going to be things that, that management in the organization is going to want to be aware of, because
I think it's also helpful for the employee to know about them.
Yes.
Because when they understand the sort of full requirements that come with pursuing outside, consulting work, they may decide to put off this job search, or to sort of pursue another, think about other strategies for achieving this sort of a different timeline, so that they can continue to finish their work at FDIC. And I think that makes a lot of sense.
So I think we can agree too then that because they're a senior employee, that
they're probably subject to the negotiating notification whenever and if negotiations commence. I suppose we could ask them to file it now.
Right.
That might be a little premature, since they've really not heard back, or it's just out there in the ether. Negotiations may never arise from this set of facts.
Right.
But that would be something to sort of work through practically how best to handle that, and it's convenient to everyone and make sure you meet the requirement.
And again, I think this is a totality of the circumstances thing though too, because I guess in my own mind, when you've got a senior employee who's in charge of the regulatory provisions of a federal regulatory agency, and you are a financial institution who's affected by that, and you have the opportunity to hire one of the senior political people or senior employees in that financial institution, I know they haven't expressed interest yet, but I would be gobsmacked if this, member bank just totally shut this person down and didn't respond to them at all. So, I mean, I guess that's all I'm saying is that it's better to know sooner rather than later. Right. And even though technically, I mean, the law says, they're not required to issue this notification. And, they have 3 days from the date that they've begun negotiating to submit this and their recusal. That again, sooner is always better if you can encourage your senior folks particularly to do this.
Yeah, we certainly want to be able to advise this person at this juncture, and whether we execute the negotiation notification now or in a day when they get the call back, we should have that discussion and figure out what makes sense for our agency.
Right.
Likewise for the recusal notification.
Right. Any calls, any people in the phone call who have questions on that one?
Again, if you'd like to ask a question, please press star and 1 and record your name, star and 1.
And likewise on the Hangout, you can type any questions in the lower right-hand corner of your screen.
No questions on the phone.
Okay.
Okay, and we're not showing any in the Hangout either. All right.
Okay, you want to continue on here?
So we're still at the FDIC with the same employee.
You can tell they're retiring. They're putting all sorts of
frequent flyer we have here. Yeah. So this person has also entered discussions with a publisher about a possible contract to begin writing a textbook after she leaves government service.
Oh, this is interesting.
This is kind of interesting.
Okay.
So first question. Is whatever this is it seeking? It's an interesting question. So I think, it's helpful to look at that expanded list of the kind of services we're talking about here. And that list is pretty expansive, right? It's basically any compensated personal services.
Right.
And I don't see writing a textbook is sort of categorically different from consulting or...
And it's per contract. It's by contract.
Yeah,
so it's a contractual
thing.
You're providing personal services for which you will be compensated by the publisher. Those personal services happen to be writing a book.
Right.
But it's all pursuant to contracts.
Right. So there's nothing special here. Right. This is just a kind of work.
Right.
So yeah, I think this is the kind of thing that you could be seeking. And then it says there are discussions. So presumably that means we're talking back and forth. We only require actually unilateral communications, but it looks like this is bilateral. So I think we're going to be comfortably over the threshold seeking there.
Yes.
And probably moving in the direction of or already in the area of negotiation, depending on what these conversations have looked like. So I think, the first box, the answer is yeah.
I agree. I think you are definitely seeking, potentially negotiating. And yes, this type of an arrangement would fall within the ambit of employment for purposes of Subpart F.
Okay.
Okay, so the next question is, do we think this person has any duties that affect the prospective employer? And I don't want to be too sanguine about this to say that, oh, well, it's FDIC and it's a book publisher. What's the likelihood? I mean, I would let FDIC decide that, whether or not that's any kind of likelihood. But
the alarms aren't going off
immediately.
But there are possibilities. We could buy books from them. They could be, who knows?
Yes.
But we want to look. But this is certainly not as an immediate of a concern as seeking or negotiating with a member bank, where we know there's a high likelihood of nexus.
Exactly.
Okay.
So is this subject to the notification requirement?
Well, it looks like it's after service. We decided this person's probably a public filer, and it's for personal services.
Right.
So it seems that they probably should file now or very, very soon. The negotiation notification.
Right. Now, it may very well be that they won't have a recusal notification that attends to that. But yes, I agree. I think that if they're having discussions, e.g. back and forth, I would argue that, that this person should should have already, or if hasn't, then should be filing a negotiation notification.
Okay. No, I think that makes a lot of sense. And this is another area of that training could be helpful.
Yes.
Because it's maybe not intuitive for all employees that writing a textbook or writing other kinds of publications constitute employment for or seeking and negotiating for employment rules. That could be sort of a surprise to them. So this might be a good example.
Well, I think it's also important too, because there are rules that apply if the work is going to begin, or the writing is going to begin before they leave government service, then there are other things for them to consider.
Right.
So this is one of those things where, yes, it's subject to Subpart F. Yes, it's subject to the negotiation notification requirement, but it may, depending upon when the writing is going to take place, et cetera,
Right.
there might be a whole lot of other things that are implicated here. So, we have a book deals advisory. If you're not familiar with how book deals work,
we have the outside activity.
We have the outside activity MOOC that you take a look at. But yeah,
we have a good question here. So the question is, do we recommend combining advice about the disqualifications for seeking and negotiating with discussions of post-employment restrictions? Or does it make sense to keep those conversations separate?
I strongly advocate that you do them together, because I think that too often folks are unfamiliar with the seeking and negotiating recusal requirements. They're unfamiliar with how those things can crop up when they're in the throes of getting ready to leave government service, and they may be more familiar with the post-government restrictions, and so they're anticipating going in and talking to you about post-government restrictions, but they can get into so much trouble before they ever come to you on post-government employment that I would train on both, because I think you want them to understand that they're kind of they're not, the restrictions aren't the same by any stretch of the imagination, but they kind of go hand in hand, and you don't want people waiting until they come to you for post-government employment to let you know about their post-government plans.
No, I think that's very good. And I think another thing is, from a customer service perspective, the scope and magnitude of the post-employment restrictions can be cogent to their seeking process. Right. That could be really invaluable information for them to have, the degree to which they'll be restricted for certain kinds of work in selecting a job for post-government. And it could be very interesting to their prospective employers. We don't want to cause anyone any unnecessary heartburn and pain. So being as transparent about that as early as possible benefits both you and the program and the agency, as well as the employee, who is fully informed as they conduct their job search. I'd maybe suggest that this isn't even an either or, that it might be an either and. So it's very good to sort of explain the scope of the post-employment restrictions with the employee at the time you're counseling them under Subpart F. But also, once you have more details about where they're going and what they're doing, it might be useful to check in again, so you can provide them really specific advice to whatever position they ultimately land on. But that's a great question.
Do we have any questions on the phone for number 5?
Again, if you have any questions, please press star and 1 and record your name, star and 1 with any questions. No questions from the phones.
Excellent, thank you. And we're not seeing any questions, any further questions on the Hangout. Which brings us to the last scenario.
Our last scenario. Okay, so we've got a FEMA employee, and this person is responsible for conference planning, setting up meetings and conferences across the United States. They have FEMA has an upcoming conference in Baltimore, and 3 hotels have responded to their RFP. And those 3 hotels were the Marriott, the Grand Hyatt, and the Crown Plaza. The planner in question is deciding which of the 3 hotels will host the conference. 2 weeks ago, our planner sent her resume to every hotel in the Baltimore area, including the 3 that responded to the RFP. But she has not heard from any of the 3 yet.
All right.
Or from anyone yet.
This is a fun one.
It is fun.
Okay, so going back to the beginning of our definition of seeking, an unsolicited communication aimed at future employment is seeking.
Yes.
And the only time we ever move that back is if the only matters we're working on are matters of general applicability.
Right.
This person's working on a contract. We're doing an RFP. We're going to spend some money. Contracts or specific party matters.
Right.
Our contractor is seeking right now.
Yes, she is. Does it matter? Does it matter at all that she has basically blanketed the Baltimore area and Baltimore hotels with her resume? Does that somehow dilute the seeking issue such that we don't worry about it as much, or somehow that because she's sent them out to everyone and they're all kind of...
Only in that doing her job just got a whole lot harder. No, it doesn't make any difference whether she sent it just to Marriott or if she sent it to Marriott and Crown Plaza and everyone else under the sun. She's seeking with all of them.
Right. So the issue isn't how many resumes did Mary Jo send out. The issue is not... Except when
we're deciding the breadth of her recusal, which is going to get bigger with every single resume.
The question isn't, because she mass mailed her resume, does that somehow absolve her from seeking until she hears something from...
Not at all.
It doesn't.
It absolves her from being a conference planner in the Baltimore area for the next 2 months. She might have to take some administrative leave.
So the facts to look at, what we're focusing on here is what are the matters that she is working on at the moment, and do any of the matters she's working on discreetly affect affect anyone to whom she sent a resume.
And in this case, absolutely.
Absolutely.
She can't do this.
She can't. No,
so the recusal starts now.
Yes.
She can't work on this RFP. She can't work on this procurement. She can't work on this conference.
Right.
Until she ends this seeking activity.
Right.
Or it's ended for her.
Yeah. So what we're looking at here is she is seeking. So she has an immediate recusal requirement. So the only thing that's going to change that recusal requirement for her, as Patrick said, is if she hears back from these...
And they're not interested.
And they're not interested, or she hears back from them and she decides she's not interested and she tells them, I'm not interested in any further conversation. That's one way that her recusal requirement goes away.
Right.
But there is a second way that her recusal requirement could go away, since she's papered the entire universe with her resume, is that if within 2 months of the dispatch of the resume, and her resume has been out there for 2 weeks, okay? But if after 2 months, she's heard nothing from these three folks,
then the seeking ends until such time she hears something.
That's right.
Yeah.
That's right.
Okay. So she might have some time on her hands in the next 6 to 7 weeks.
Baltimore is just completely off the reservation for her.
She reassigned to St. Louis.
Yeah, exactly.
For
any
the
place
next
but Baltimore.
Months. Yep. Yeah. So she's made things difficult for us.
Yes.
And then for this piece of work.
So we know she's recused from Baltimore matters, from any of the things there at least for the next 2 months, unless she hears back, and then it goes from there, and we could be getting ourselves into negotiating at that point.
Right.
What about if she gets into a situation where one of them writes back and says, yes, we're really interested, and now she's in bilateral communications and she's negotiating, does she have a negotiating notification requirement?
It depends. We'd have to find out if she's a public filer, conference planner, maybe not. Depends on the agency and how they structure that kind of thing. So that would just be a factual question. Is this person a public filer? If they are, they would have to file that once the bilateral communications commenced.
Right.
This is an area where if this is a public filer, I'm not sure about doing 200 negotiation notifications for every hotel in Baltimore.
Right.
But that might also be a concern of others higher up in your organization, that you have a very senior person who's basically disqualified themselves from their job for the next 6 weeks.
Right.
They might have something to say about that.
Right. And that is one point. I think you reminded me of something. That is one point that I want to make abundantly clear with folks, is that negotiation notification requirement, if it applies, you have to report your negotiating, even if you don't have any matters that could affect. So it's not like you only have to submit a negotiation notification if you have also a recusal requirement, which is to say if you can affect the person with whom you're negotiating for employment. If the requirement is met, which is to say that you're a public filer, you're negotiating for employment, and it's going to happen post-government, like the employment will be post-government, you have that requirement irrespective of whether or not you have any conflict of interest or appearance of conflict of interest with the person with whom you are negotiating for employment. And in this case, with this female employee, we have no indication necessarily that she's a public filer. If she is, she would be subject to that negotiation notification. And again, assuming that it would be for post-government employment.
Right.
If it's concurrent employment, then she would not have, no one would have the negotiating requirement, notification requirement.
We have a question. So I think this is an interesting amendment to our fact pattern. So say we change the facts just a little bit and say the employee is not part of the source selection, but is someone who will be working with the hotel once they're selected. So in sort of requesting things of the hotel, configuring the space, signing up the rooms, and on and on and on. What's the scope of the recusal in that case?
I mean, I think that's where you start getting into, you'd have to look at what the duties and responsibilities of that person would be, because if anything they're doing is personal and substantial participation in the contract, then I would argue they're still going to have a recusal requirement with respect to the hotel that is selected.
Right. So you see, sort of here, that's sort of a clarification. That question is, how do we know if the thing she's participating in will affect the financial interest of the hotel? And that contract, that matter that's being executed, does affect them. Right. So her participation personally doesn't have to affect the hotel significantly, right? So she calls the AV guy and says, you need to run over here because our thing's not working. That's probably personal and substantial participation in the contract, in the overall matter. So she would have to be recused from that. Exactly, because that's the matter that will affect the financial interest of the hotel is the contract. Right. So that's just that. The contract, they have a financial interest in the contract. So then the question becomes, if the employee is going to be able to participate personally and substantially in that contract. Right. Now, if they are simply going to be at the registration desk helping to set up and whatever, and they will have no interface with the hotel, and they will not be in a position to, as you said, call on AV, which could incur additional charges, or to be engaged in anything that would reach materially to the contract, then maybe she wouldn't have a recusal requirement. I think if someone had that very minor role, this is a place where, especially when they're at this mere seeking place, the Subpart F authorization might be appropriate. Right. Right. You could say, look, as long as you're not directing their employees, you're just participating on the government side to deal with our guests or whatever. In an abundance of caution, you could scope that out in a Subpart F authorization because she's merely seeking at this juncture. Right. And you'd have to revisit that if negotiations began. But thanks, Alex. That's a great question. All right. So are there any questions on the phone with respect to either 6 or any of the other questions that are any of the other scenarios that we...
Again, if you have a question, press star and 1 and record your name. Again, star and 1 with any questions.
One final thing, we didn't really get to touch on a whole lot today, but I really encourage you to read the advisories that we've given you copies of, particularly the 2004 advisory that we gave you on seeking employment, because in that we really talk about what you should consider in the event that you have a situation where recusal isn't really optimal. Right. To be looking at maybe limited waivers or limited authorizations. If you think at all that might be something that you're going to have to consider, be thinking about that now, and be thinking about sort of like policy-wise, like what your sort of like parameters are going to be, because as OGE has stated on many an occasion, including in this advisory, we think waivers for negotiation for employment should be rare. Because we think it's the standard for a B1 waiver, which is the employee's interest is not so substantial to be deemed likely to affect the integrity of their services, is a really hard standard to reasonably argue when you're dealing with potential salary. You're dealing with the outside employer's entire financial interest, and you're also dealing with the employee's interest in prospective employment, and that's a pretty personal, pretty profound interest, particularly for a departing employee who, is looking for a place to land. So again, it is the agency's discretion to authorize a waiver, but please read these advisories and have that inform your decisions about when it is not appropriate to consider a waiver.
And we are drawing to the close of the hour, and we're not showing any further questions on the Hangout. Do we have any further questions on the phone?
No questions on the phone.
Excellent.
Okay.
Well, sure. Well, thank you for joining us.
Well, thank you for having me.
And this has been a really, I think, a very helpful massive open online course. And this is an area that, we took a look at the offerings that we had on the YouTube channel. We found that this is a gap. So hopefully you find this to be both timely and helpful, and also a resource for the future. We also hope that you'll join us next Thursday for the next presentation, our Transition Readiness series. The registration opened this morning, and we'll be talking about training strategies for career or senior executive service employees who will be staying on through the transition, because we think they face some kind of unique issues during that time period. And if you have an opportunity to train either in a formal way or a less formal way, we'd like to talk about some strategies and some tools that you can use to support those folks. So thank you all for joining us, and we hope to see you next time.
Good afternoon.